My name is Nadia. I am 31 years old and I live in Atlanta, Georgia. And I want to tell you about the worst year of my life. A year that began with loss and ended with a courtroom, and that taught me things about family and money and love that I wish I had never needed to know. My mother's name was Ruth. My father's name was Charles. They were married for 38 years, lived in the same house in Decatur, Georgia for 30 of those years, and raised two children with the specific combination of high expectations and unconditional love that produces, in the children lucky enough to receive it, a deep and abiding sense of what is worth fighting for. My father died first, a heart attack in September, sudden and without warning, the kind of death that does not give anyone time to prepare. I was at work when my brother called. I remember sitting very still at my desk for a long moment, holding the phone after the call ended, looking at my computer screen without seeing it, before something in me that had been holding everything in place simply stopped working, and I had to leave the building to cry in my car. My mother lasted 8 months after him. I say lasted because that is the word that fits. She did not thrive after my father's death, did not rebuild around the absence the way some people do. She grieved him completely and consistently, the way a person grieves when they have spent 38 years constructing a life around someone and cannot imagine its architecture without them. Her health declined steadily. The cancer she had been managing for 2 years accelerated in those 8 months, and she died in May of the following year, in the house on Ellenwood Drive, with me beside her. My brother Kevin drove up from Savannah for the funeral. He is 7 years older than me, 38 to my 31, and the years between us had always created a particular kind of distance that was not unfriendly but was real. He had left Decatur at 22 and built his life elsewhere. A career in commercial construction management, a house in Savannah, a wife named Sandra who I had met perhaps a dozen times over the years, and who had always been pleasant to me in the surface-level way of someone who is performing pleasantness rather than experiencing it. He was not absent from our parents' lives. He called, he visited several times a year, but the daily texture of caring for aging parents, the Saturday afternoon grocery runs, the doctor's appointments, the evenings spent sitting with my mother through chemotherapy, watching whatever she wanted on television, that texture had been mine for the last 2 years, because I lived 40 minutes away and Kevin lived 4 hours away, and proximity is its own kind of default assignment. I had not resented this. I want to be clear about that, because the story I'm about to tell you might sound like the resentment of someone who believed she was owed something for service rendered, and it was not that. I cared for my parents because I loved them, and because I was there, and because the alternative, not being there, was never something I seriously considered. I bring this up because it becomes relevant in ways I will explain to what Kevin said to me 3 days after my mother's funeral. The gathering after the burial was at the house on Ellenwood Drive, the house that my parents had owned for 30 years, a 4-bedroom colonial, modest by some standards and substantial by others, the kind of house that in Decatur's changing market had quietly appreciated to a value that would have astonished my parents if they had known, the area having transformed around them while they lived inside its ordinary rhythms. The house where my mother had made her kitchen the center of every gathering for 3 decades, where my father had maintained the backyard vegetable garden with the same methodical care he brought to everything. The family filled it that afternoon. Aunts and uncles, cousins, my parents' church friends, neighbors from the street who had known them for 20 years, the kind of gathering that is both comforting and exhausting, where you repeat the same sentences about loss to different people for 3 hours while your actual grief waits patiently somewhere behind your sternum for a quieter moment to be fully felt. Kevin found me in the kitchen near the end of the afternoon when most people had gone and the house had returned to something closer to its ordinary quiet. He had a glass of water in his hand and the specific, reassuring expression of an older brother who has always been the practical one, who handles things, who can be trusted to sort the complicated parts while the emotional one processes. I said, "Okay." I should have asked more questions, but my mother had been buried 6 hours earlier, and I was 31 years old, and I had just lost both parents in 8 months, and there was a specific limit to what I could hold in my mind and heart simultaneously. I said, "Okay," and Kevin went to find Sandra, who was already looking at the kitchen with the evaluating expression of someone taking inventory. That expression was the first thing I did not know to do with. I would understand it later. When everything else became clear, I would understand that expression precisely. I drove home to Atlanta that night, and I sat in my apartment in the specific bottomless quiet of a person who has no parents anymore, which is a feeling that those who have experienced it will recognize, and those who haven't cannot be fully prepared for. Not the acute grief of the first hours, I had passed through that earlier at the graveside, but something deeper and more permanent, the realization that there was no longer a house where your childhood lived in the smell of the rooms, that the two people who had known you your entire life were both gone, and that the world had reorganized itself around an absence that would not get smaller. I let myself feel all of this. I did not think about Kevin's words that night, or Sandra's expression, or the word executor and what it contained. I grieved, properly and completely, the way the situation required, because I understood even then that what Kevin had started in that kitchen conversation was going to require me to be clear-headed and precise and completely awake. And grief, real grief, needed to be felt first before it could be set aside for the work.
But the plan for what to do with the role, I believe, had been Sandra's. The invisible labor of the last 2 years weighed on me differently after the estate dispute began. Not because I had done it expecting compensation. I want to say this clearly enough that it cannot be misread. I drove to Decatur on weekends because I loved my parents. I sat through chemotherapy because my mother needed someone there, and I was the one who could be. I managed medication schedules and doctor's appointments and the 1,000 small practical details of an aging parent's life because it needed to be done, and I was there. I would do all of it again. But there is a specific, exhausting irony in discovering that the sibling who had been largely absent from the daily texture of your parents' care was simultaneously positioning himself to take the largest share of what they left behind. The irony does not cancel the love. It cannot, and I would not want it to. But it sits heavily, and I want to be honest about that weight, because I think a lot of people who are watching this have felt it in their own families, in different forms. The one who shows up often ends up with the least. Not because the parents intended it that way, mine absolutely did not, as I would eventually discover, but because the one who shows up is focused on the showing up, not on the legal machinery of what comes after, and the one who stays away has more mental and emotional bandwidth to think about the machinery. There is a specific memory I return to often, from about 6 months before my mother died. I was in the backyard of the Ellenwood Drive house on a Saturday afternoon, weeding my father's vegetable garden, which I had maintained in his absence because I could not bear to let it go untended. My mother was sitting in the garden chair nearby, wrapped in a blanket even in the summer heat, watching me work with the slightly dreamy focus of someone whose energy is conserved for observation. She said, out of nowhere, "Nadia, you know your father and I tried to be fair." I looked up. "I know," I said. "We did our best," she said, "with both of you. We wanted everything to be clear." She paused. "There's a letter in the deposit box at First National. Kevin has the key, but you have the right to the box. Make sure you remember that." I noted it, filed it, but did not yet understand what it meant. "I know, Mama," I said. "Don't worry about that right now." She nodded, pulled her blanket tighter, and watched me work. I did not know then that she was telling me something important, that she had seen something, understood something, and was doing the only thing she could do about it, leaving a trail for me in a safety deposit box against the possibility that clarity would be needed and she would no longer be there to provide it. She had tried to protect me, in the only way still available to her. I would not understand this until many months later, in an attorney's office, when I finally remembered to ask about the box.
To understand what happened with Kevin is you need to understand what Kevin and I had been to each other and to our parents for 31 years before the estate became something to fight over. We were not close in the way that siblings close in age are sometimes close. The kind of closeness built on shared bedrooms and overlapping friend groups and the mutual memory of the same childhood moments. Kevin was 7 years older, which meant that by the time I was forming real memories, he was already a teenager with his own world. And by the time I reached high school, he had already left for college and the rest of his life. But we were not estranged. We were the kind of siblings who existed in the same orbit without collision. Cordial at family gatherings, occasional phone calls at holidays, the periodic update exchanged with genuine, if not deep, interest. He came to my college graduation. I went to his wedding. We occupied the category of family in the functional sense, which is not nothing. What we were not, and what I had never fully examined until this year, was honest with each other about what our respective relationships with our parents had actually been. My parents were people of deliberate, expressed love. I want to make sure you understand this before I tell you about the imbalances, because the imbalances were real and consequential, but they existed inside a family that was fundamentally loving, and those two things can both be true. My father, Charles, was a quiet man with enormous practical competence. He could fix anything mechanical, managed the family's finances with meticulous care, and communicated love through acts of service rather than words, though he was not incapable of words when they mattered. He taught me to balance a checkbook at 12 and to change a tire at 15, the specific gifts of a father who wanted his daughter to be capable in the world. My mother, Ruth, was warmer in expression, a woman whose kitchen was the center of every gathering, who remembered every detail of every conversation, who had this specific quality of making whoever she was talking to feel like the most important person in the room. She had worked as a school counselor for 25 years and had brought the same patient, attentive care she gave her students to everything she did, including raising two children who were very different from each other. They loved Kevin and me in ways that were both equal and different, the way love accommodates different personalities by finding each person's specific language. Kevin was the practical one. He handled logistics, managed problems, spoke the language of systems and solutions. My father related to him most naturally through this shared orientation, weekend projects, financial discussions, the specific respect between two men who both valued getting things done correctly. I was in my parents' eyes the one who showed up. Not instead of Kevin, he showed up too in his way, but differently. I was the one who drove back from Atlanta on a Sunday afternoon when my mother mentioned carefully and without complaint that she was having trouble sleeping. I was the one who sat in the chemotherapy suite for 4 hours with her, bringing the specific snacks she had mentioned liking, watching the television shows she chose, holding her hand during the parts that were difficult. I was the one who knew her doctor's name, her medication schedule, the specific fears she mentioned only in the late evenings, when the house was quiet and defenses were lower. My father had trusted Kevin with the practical administration of the estate because Kevin spoke that language fluently, because he was older, because the assignment made a certain obvious sense given their respective orientations. What my father had not fully accounted for, what neither of my parents had fully accounted for, was what Kevin would do with that trust when there was money involved and I was not in the room. I want to tell you something about Kevin and Sandra that I noticed but did not name clearly enough in the years before all of this happened. Sandra was not a bad person. I want to be precise about this because this is not a story about a villainous sister-in-law who corrupted an otherwise good man. Sandra was a practical, acquisitive person who had married a practical, acquisitive man, and who had, over the course of their marriage, gradually become the primary voice in their household's financial decisions. She tracked their assets, their investments, their savings, with a focused attention that Kevin sometimes described with pride. Sandra handles all of that. She's very good with money, and which I had always received as a benign personality trait rather than relevant information. I understood after everything that happened that the way Sandra looked at that kitchen on the day of my mother's funeral was the look of someone who had already been having a different set of conversations than the ones I was part of. Kevin had been executor in name for years.
The attorney needed additional time. There was a question about a lien on the property that needed to be resolved before valuation could proceed. The market was uncertain, and a premature valuation might underserve the estate. There was a question about whether certain personal property, my father's tools, my mother's jewelry, qualified as estate assets or had been gifted informally before their deaths. Each individual excuse was plausible. The estate administration, as I knew from cursory research, could legitimately take months. Executors had real responsibilities and real timelines. Not every delay was sinister, but the accumulation of them, the specific pattern of deflection and new complications arriving precisely when I pressed for specifics, and above all, the fact that Sandra was increasingly appearing in conversations that were legally and ethically Kevin's responsibility alone. All of this had moved me by the fourth month from discomfort to something closer to certainty. I was being managed, not toward resolution, away from it. I called my cousin Diane, who had worked in a law firm for 15 years, as a paralegal, not as an attorney, but as someone who knew the landscape. "Tell me what I know," I said, and I told her everything. The timeline, the excuses, Sandra on the phone, the house that was being valued for 4 months after my mother died. Diane listened without interrupting. When I finished, she was quiet for a moment. "Nadia, 4 months is not unreasonable for an estate, but the fact that you haven't been provided any documentation, no inventory of assets, no accounting of the debts you were told about, nothing in writing, that's a problem. As a beneficiary, you have the right to information. The executor is obligated to keep you informed." "What do I do?" I said. "You need your own attorney," she said, "not Kevin's attorney. The estate's attorney is technically the estate's, not yours. You need someone representing your interests specifically." I had known this somewhere for weeks. Hearing it from Diane clarified the hesitation I had been navigating, the resistance to believing that the situation required this, that my brother was doing what I was increasingly certain he was doing. "If I hire an attorney," I said, "I'm saying I don't trust him." "Yes," Diane said, "that's correct." A long pause. "Nadia," she said gently, "do you?" I thought about Sandra on the phone. I thought about the house being valued for 4 months. I thought about the documentation that never arrived, and the questions that never been answered, and the specific quality of Kevin's reassurances, which had the texture of things designed to end a conversation rather than resolve a concern. "No," I said, "I don't." "Then you know what to do," she said. I hired an attorney named Patricia Osai 2 days later. She was recommended by Diane, practiced estate litigation in Atlanta, and had the specific, unhurried directness of someone who had spent years in rooms where families were fighting over money, and long since been surprised by what people did to each other when inheritance was involved. "Tell me everything," she said at our first meeting. I had brought the notebook. I told her everything. She listened, took her own notes, asked precise questions, and at the end of the meeting said, "I'm going to request the estate inventory and accounting from the executor's attorney. This is your right as a named beneficiary under Georgia law. If everything is in order, we'll have documentation within 2 weeks, and you'll have the information you need." "And if it's not in order?" I said. She looked at me with the steady, measured expression of someone who had already formed a preliminary assessment of the situation and was being responsible about how she delivered it. "Then we'll know what we're actually dealing with." 3 weeks later, we knew.
The first month after my mother's funeral, I gave Kevin space. I tell myself this was reasonable. Grief has its own timeline. Estate administration is genuinely complex. And 7 years of being the practical one in the family had established Kevin's credibility in this space in ways that were not irrational for me to respect. I had told myself a story in those early weeks, in which Kevin's promise to handle everything was a gift, one less burden during an already unbearable period, rather than what it was actually beginning to be. I called him twice in the first month. Both calls were brief, warm, and uninformative. The estate was being assessed. The attorney was working through the documents. These things take time, Nadia. Both times, I accepted this. I had a job to return to, an apartment that had been neglected during weeks of back and forth to Decatur, the specific logistical rebuilding of an ordinary life that had been set aside for grief. I let myself be reassured, and I went back to the work of continuing to exist. The second month, I called 3 times. The first call went to voicemail. Kevin called back 2 days later, briefly, with the same formulations: attorney, timeline, complexity. I asked a specific question: what was the current status of the house on Ellenwood Drive? He said it was being valued. I asked whether I needed to sign anything. He said not yet. The second call produced Sandra. Not Kevin, Sandra, answering his phone in the specific, practiced way of someone who has been delegated this particular conversation. She was warm, efficient, and relayed essentially no real information with the smooth fluency of someone who had done this before. The attorney was handling everything. Kevin was very busy with a large project at work. Everything was on track. She would have Kevin call me when there was something concrete to report. I hung up the phone and sat with the feeling that had been building, quietly and insistently, for 2 months. Something was wrong. The third month, Kevin called me. This was notable because Kevin had not been the one initiating calls, and the shift in pattern registered immediately. He was calling, I understood as soon as I heard his tone, to deliver information he had decided, or Sandra had decided, was better delivered proactively than discovered. There were some debts, he said. Mom had some medical bills that weren't covered by insurance, and Dad had a small line of credit that we're clearing. It's going to affect the estate distribution somewhat. How much? I said. Not dramatically. I just wanted you to be aware. Kevin, I need specifics. What are we talking about? I'll send you the documentation when the attorney has it compiled. When will that be? A few weeks. I wrote down the date and time of the call in a notebook I had started keeping, not because I had fully committed at that point to the belief that I needed documentation, but because something in me had understood, without my full conscious acknowledgement, that I was in a situation where records would matter. What arrived instead over the following weeks was a gradually escalating series of reasons why clarity was not yet available. The documents arrived on a Thursday. Patricia called me at 9 in the morning and asked me to come to her office that afternoon, which I understood immediately as a signal. She had said, at our first meeting, that she would send straightforward documentation by email if everything was in order. A phone call asking me to come in meant it was not in order. I rearranged my afternoon and drove to her office in Midtown Atlanta with the specific, controlled composure of someone who has been preparing for weeks to receive bad news and has decided in advance how they are going to carry it. Patricia's office was organized with the methodical efficiency I had come to associate with her. Everything in its place, nothing decorative that did not also serve a purpose. She had the documents laid out on the conference table when I arrived, organized with colored tabs that I understood were her system for categorizing what she had found. She did not ease into it. "I'm going to walk you through what I found," she said, "and I want you to let me finish before you respond, because there's a significant amount of information, and it will make more sense as a complete picture than in pieces." "Okay," I said. "Take notes if it helps," she said. "And I want you to know, before I start, that everything I'm about to show you is documented, legally specific, and actionable. This is not a situation where I have concerns that might amount to something. This is a situation where the evidence is clear. She began. The first thing she showed me was a property deed. The house on Ellenwood Drive, my parents' home of 30 years, the house where I had grown up, where my mother had made her kitchen the center of everything, where my father had tended his vegetable garden for 2 decades, had been transferred into Kevin's name. Not the estate's name, not a trust, Kevin's name, his personally. The transfer had been executed 11 weeks after my mother's death. The documentation Patricia had obtained showed it had been filed with the county recorder, while the estate was still open and active, while Kevin was still serving as executor, while I had been waiting for updates that never came, while Sandra had been answering Kevin's phone to tell me everything was on track. I looked at the deed. I read Kevin's name in the ownership line. I did not speak for a long moment. "When was this filed?" I said. 11 weeks post-death, week 16 of your mother's passing, while you were being told the property was still being valued. I absorbed this. "The second item," she said. The second item was a bank account. My parents had maintained a joint savings account for 30 years, a consistent, careful accumulation that had grown over decades of modest and methodical contribution to a significant balance. I had known the balance in the general way that adult children know about their parents' finances without knowing the specifics. I had not known the balance. Patricia showed me the balance. Then she showed me the withdrawal records. Beginning 6 weeks after my mother's death and continuing over the following 8 weeks, the account had been drawn down in a series of withdrawals, some large, some smaller, conducted with a frequency and pattern that did not resemble debt clearance, but rather the systematic movement of funds. The account now held a small fraction of its previous balance. Kevin had been named as an authorized signatory on the account. This was legitimate, a practical arrangement my parents had made when they updated their estate planning. The authorization to access the account did not, however, give him the legal right to withdraw funds that were estate assets for his own benefit. "Is this illegal?" I asked. "Potentially criminal. At minimum, it is a serious breach of fiduciary duty as executor. At maximum, depending on what he did with those funds, it could constitute theft from the estate. That distinction will depend on where the money went, which we can pursue through discovery." She moved to the third item.
The third item was a set of estate filing documents. Kevin had filed through the estate's attorney an asset inventory with the probate court. This was a required step in estate administration, a formal accounting of what the estate contained. The inventory Kevin had filed was incomplete in ways that were not accidental. Several assets were absent, specific pieces of my mother's jewelry that had been appraised as part of the estate's personal property, my father's tools, a significant collection of professional-grade woodworking equipment accumulated over decades, which had a real market value, and most significantly, the property on Ellenwood Drive was listed not at its current appraised value, but at a figure substantially lower, in a filing that had been completed before the transfer of the deed that should have been impossible to execute given the property's estate status. Patricia walked me through each of these discrepancies with a systematic thoroughness of someone building a case rather than sharing information, which was precisely what she was doing. When she finished, the table was covered in organized, tabbed, thoroughly documented evidence of what my brother had done. I sat in that conference room for a long moment. I had grieved my parents. I had taken bereavement leave, returned to my life, called my brother with careful, trusting questions, accepted his reassurances, given him the benefit of the doubt that family earns by default until it demonstrates that the default was a mistake. I thought about my mother in the garden chair, wrapped in her blanket. "There's a letter in the deposit box at First National. Make sure you remember that." "The safety deposit box," I said to Patricia. She looked up. "That box is potentially very important. We need to access it. As a named beneficiary, you have legal standing to request access. I'll make that call today."
The box contained the letter. We accessed it within the week, with Patricia present and the bank's manager facilitating the process. My mother's handwriting on a cream envelope, not a legal document, a personal letter, dated 4 months before her death, addressed to both of us. I will not read you the entirety of what she wrote. Some of it is mine alone, the specific private communication between a mother and her daughter that belongs in the category of things not meant for larger audiences. But what is relevant to this story, what became central to the legal case that followed, is what she wrote in the final 2 pages. She wrote that she and my father had always intended the estate to be divided equally between Kevin and me. She wrote that she had observed in the months since my father's death that Kevin had begun making inquiries about the property and accounts that concerned her. She wrote that she trusted Kevin, but that she also understood him, which was a different thing, and that she wanted there to be no ambiguity about her intentions. She wrote, "The house is both of yours. It has always been both of yours. If anyone tells Nadia otherwise, they are not telling the truth. My father and I worked 30 years for that house, and we worked it equally for both of our children." She had dated it, signed it, and had it witnessed by 2 friends, her church friend Carolyn and her neighbor Mrs. Washington, whose names were printed clearly beneath their signatures. My mother, from a garden chair in the backyard she loved, wrapped in a blanket in the summer heat, had done the only thing she could still do. She had made me a witness.
I asked Patricia for 2 weeks before filing anything. She accepted this because she understood, without my needing to explain it fully, that what I was asking for was the space to attempt something that had almost no chance of succeeding, but that I needed to attempt in order to be able to live with whatever came next. I needed to talk to Kevin first. Not because I believed he would hear me, not because I had any realistic expectation that the confrontation would resolve the situation, but because this was my brother, the person who had grown up in the same house, who shared the same parents, who had stood beside me at 2 funerals in 8 months. And I was not going to take him to court without first looking him in the eye and giving him the opportunity to understand what I knew and to choose a different path. I called him and asked for a meeting. He agreed, with the ease of a man who did not yet know what I had found. We met at a coffee shop in Buckhead, neutral ground, on a Saturday morning 2 weeks after my meeting with Patricia. I arrived first. I had the documents in a folder in my bag, not to slam on the table in a dramatic gesture, but because I had learned from Patricia that clarity required specificity, and I was not going to conduct this conversation in the vague territory of feelings and accusations without the precision of evidence. Kevin arrived 8 minutes late, in the particular way that people who are unconsciously uncomfortable with a situation are late. Not dramatically, but with the specific timing of someone who has needed slightly longer than usual to compose himself for something he doesn't fully understand. He ordered coffee. He looked at me with the easy confidence of a man who had not yet received the information that would reorganize everything. "You sounded serious on the phone," he said. "I am serious," I said. I placed the folder on the table. I did not open it yet. I hired an estate attorney, Patricia Osei, out of Atlanta. She requested the estate documentation on my behalf. Something shifted in Kevin's expression, barely perceptible, a slight tightening around the eyes, a recalibration of posture. He knew, from that sentence, what was coming. He had known, I believe, from the moment I requested the meeting. "Okay," he said carefully. "She found the deed transfer. The house was transferred into your name 11 weeks after Mom died, while you were telling me the property was still being valued." He was quiet. "She found the account withdrawals, the savings account that Mom and Dad built for 30 years, significantly drawn down in the 2 months after Mom died." Still quiet. "She found the incomplete estate filing, assets missing from the inventory, the house listed at a fraction of its assessed value." I paused. "And she helped me access the safety deposit box at First National, the one Mom told me about in the backyard, the one with the letter." Kevin set down his coffee cup. For a long moment, neither of us spoke. "Kevin," I said, "I'm not here to destroy you. I'm here because you're my brother, and because Mom and Dad raised us to be better than this, and because I believe, somewhere, you know what you've done is wrong. I'm asking you, I'm giving you this one opportunity to make it right before this goes to court."
What he said next was the thing that removed the last possibility of a private resolution. He did not apologize. He did not admit to anything. He leaned back in his chair with the specific, recalculating expression of a man who has decided that the correct response to being caught is not honesty, but repositioning. "Nadia," he said, in a tone so carefully controlled that I understood Sandra was in every syllable of it, "you showed up at the end. You drove up on weekends and sat in the chemo suite, and you think that makes you the central figure in their lives. It doesn't. I was handling finances. I was handling real things. What you did was emotional support, which I appreciate, I do, but that's not the same as building what they had. The estate is complicated, and there were decisions that needed to be made, and I made them as executor." I held his gaze. "Mom left a letter," I said, "in her own handwriting, witnessed by 2 people, stating clearly that the house was meant for both of us, and that anyone who said otherwise was not telling the truth." He looked at the table. He said, "I think that if you pursue this legally, you'll find it's more complicated than a letter, and you'll spend a lot of money to get a lot less than you're hoping for, and you'll lose a brother in the process." I looked at him for a long moment. I thought about the garden chair, the blanket. "Make sure you remember that." "Kevin," I said, "you lost a sister when you transferred that deed." I picked up my folder. I left the coffee shop. I called Patricia from the parking lot. I said, "File it."
Filing the suit did not feel like victory. I want to tell you that clearly, because I think there is a version of this story, the version that exists in a movie or a simple narrative, where the decision to fight becomes immediately empowering, where the protagonist strides forward with clarity and momentum and the knowledge that justice is imminent. That is not what it felt like. What it felt like was the specific, exhausting weight of a decision that was right and costly at the same time. The knowledge that I was entering a process that would take months, consume money I had not budgeted for, require me to describe the worst year of my life in legal documents to people who did not know me or my parents, and end with either a judgment that restored some semblance of what should have been mine, or a defeat that would cost me both the estate and the energy spent fighting for it. I filed anyway, because my mother had left me a letter in a safety deposit box and had asked a neighbor and a church friend to witness her signature, which told me she had known something like this might happen and had done the only thing she could to prepare for it. I was not going to let that preparation go unused. Patricia filed the complaint in the probate court of DeKalb County on a Monday morning in November, 6 months after my mother's funeral. The complaint alleged breach of fiduciary duty against Kevin as executor, improper transfer of estate property, unauthorized withdrawal of estate funds, and failure to provide accurate estate accounting to a named beneficiary. It sought the invalidation of the deed transfer, restoration of the withdrawn funds, a full and accurate estate inventory, and appropriate distribution to me as a co-beneficiary under the will. Kevin responded through his attorney, a man named Gerald Whittemore from a Savannah firm, within the required timeframe, denying the primary allegations and asserting that the deed transfer had been a proper exercise of executor authority, that the account withdrawals had been for legitimate estate expenses, and that my mother's handwritten letter was not a legally binding document and should be given limited weight. Patricia had expected all of this. She walked me through his attorney's response at our next meeting with the specific, unhurried calm of someone who has read 100 of these and is neither surprised nor alarmed. "This is standard," she said. "They're not going to admit anything voluntarily. That's what discovery is for." Discovery was the part of the process I had not fully anticipated. It lasted 3 months and required Kevin and his attorney to produce financial records, communications, and documentation related to all estate transactions. Patricia requested bank statements, phone records between Kevin and the estate's attorney, emails between Kevin and Sandra during the relevant period, and all documentation related to the deed transfer and its legal basis. What discovery produced, gradually in installments as documents arrived and Patricia reviewed them, was a picture that was worse in some respects than what I had already known.
The account withdrawals had not been for estate expenses. A portion of them had gone directly into Kevin and Sandra's personal joint account, traceable through the bank records. The deed transfer had been prepared with the assistance of the estate's attorney, who had subsequently been sent a letter signed by Kevin as executor, asserting that the transfer was permitted under an informal understanding with my parents that existed nowhere in writing and contradicted the explicit terms of the will. And the emails between Kevin and Sandra, produced reluctantly and after a motion to compel, told a story that was as comprehensible as it was painful. A months-long conversation, beginning in the final weeks of my mother's illness, in which Sandra had laid out a specific strategy for consolidating the estate's primary assets before I could request documentation or legal representation. Sandra knew what was in the will. Sandra had identified the window, the period of grief and exhaustion immediately following my mother's death, as the optimal time to move. And Kevin, who loved his wife and trusted her financial judgment, and had perhaps convinced himself that what she was proposing was only a more efficient version of what his executor role permitted, had followed the plan. I read those emails in Patricia's conference room and felt something I can only describe as a grief that had no object. Not anger, not the heat of betrayal, but a deep and structural sadness for two people who had worked 30 years for a house and trusted their son to honor what they had built. The letter became, as Patricia had predicted, the center of the case.
Kevin's attorney argued that a handwritten personal letter, however witnessed, was not a testamentary document and could not override the formal will or the executor's authority. Patricia argued that the letter was evidence of testamentary intent, corroborated by the terms of the existing will, which distributed the estate equally, and that it was directly relevant to the question of whether Kevin's transfers had been made in good faith or in deliberate defiance of his parents' known wishes. The judge, a measured, unhurried woman named Judge Caldwell, who had the specific quality of someone who has heard many variations of this particular story and was entirely focused on the specific version in front of her, allowed the letter into evidence. Patricia read the relevant passages aloud in the courtroom. I sat at the plaintiff's table and listened to my mother's words, the words she had written in the backyard, in the garden chair, wrapped in a blanket in the summer heat, read into the official record of a legal proceeding. The house is both of yours. It has always been both of yours. I looked straight ahead. Kevin was at the defendant's table across the aisle. I did not look at him, but I heard him shift in his seat when Patricia read those words, and I noted it, and I let it be what it was. The hardest day of the trial was not the judgment. It was the day I testified. Patricia had prepared me thoroughly. Weeks of preparation, mock questions, the specific discipline of answering only what was asked without elaboration, of maintaining composure in the face of Gerald Whittemore's cross-examination, which I knew would attempt to characterize me as a grieving sibling inventing a grievance. Whittemore was skilled. He asked about my presence during the estate administration. Had I attended executor meetings? Had I reviewed documents when offered? Had I ever formally requested information in writing before hiring Patricia? I answered honestly. No, I had not attended formal meetings I was not invited to. I had accepted verbal updates because I had trusted the person providing them. I had not requested information in writing before hiring Patricia because I had not known at first that what was happening required written requests. Whittemore attempted to characterize this as passivity, as a beneficiary who had not engaged with the process and was now disputing outcomes she had passively permitted. Patricia addressed this in redirect with the documentation from my notebook, the dates of my phone calls, the specific questions I had asked, the responses I had received,
and the pattern of deflection and delay that had preceded my decision to hire representation. Judge Caldwell listened to all of it with the complete, focused attention of someone performing the specific function she had been appointed to perform. When I stepped down from the witness stand, I felt the specific exhaustion of someone who has done a difficult thing correctly and is not yet permitted to rest. I sat back down beside Patricia. "You did well," she said quietly. I looked at the courtroom, the formal architecture of a process designed to establish truth in the specific, imperfect way that human institutions establish truth, and I thought about my mother's letter entered into evidence, carrying her intentions into a room she had never seen. I thought she would have been glad the letter existed. I thought she would have been very sad that it was necessary.
Judge Caldwell issued her ruling on a Tuesday morning in February, 9 months after my mother's funeral, 3 months after Patricia filed the initial complaint, 14 months after my father died. Patricia and I were at the plaintiff's table when the judge took her seat. Kevin and Gerald Whitmore were at the defendant's table. Sandra was in the gallery behind Kevin, which I noted without looking directly at her. Several family members, cousins, and aunt were also in the gallery, which I had not anticipated, and which added a specific, complicated weight to the already heavy atmosphere of the room. I had imagined this moment many times during the preceding months. Not obsessively, I had tried, with limited success, to maintain the discipline of not building toward a moment that had not yet arrived. But in the honest accounting of my inner life during those months, I would not claim I had never imagined how it would feel to hear a judge rule in my favor, to have the documented truth of what Kevin had done formally and publicly acknowledged. What I had not fully imagined was the grief. Judge Caldwell read her ruling in the measured, precise language of a judicial decision, language designed for clarity and legal precision rather than narrative or emotional resonance, and which therefore landed with the specific, slightly disassociated quality of important information delivered in an unfamiliar register. On the primary question of the deed transfer, the transfer was invalidated. The property on Ellenwood Drive was returned to the estate for proper administration and distribution in accordance with the will's terms. Judge Caldwell found that Kevin had exceeded his authority as executor in executing the transfer, that the transfer had not been made for legitimate estate purposes, and that the evidence, including the handwritten letter and the executor's own communications, demonstrated that the transfer had been made in conscious disregard of the testamentary intent of both parents. On the account withdrawals, Kevin was ordered to restore the withdrawn funds to the estate account, minus documented legitimate estate expenses which the court had identified from the discovery materials. The portion of withdrawals that had been traced to Kevin and Sandra's personal account was to be restored in full with interest. On the estate filing, Kevin was ordered to provide a complete and accurate estate inventory within 30 days, subject to court review. On legal costs, Kevin was ordered to pay a portion of my attorney's fees, reflecting the court's assessment that the litigation had been necessitated by his conduct as executor. Patricia placed her hand briefly on my forearm when the ruling concluded, a professional gesture, restrained but carrying the specific warmth of someone who had spent months working toward this moment and was marking it.
I looked at Kevin. I had not allowed myself to look at him directly during the trial. It had been a discipline I imposed on myself, a decision that looking at him would require me to feel things that would interfere with the focused clarity the process required. But now, with the ruling read and the formal proceedings moving toward their conclusion, I let myself look. He was sitting very still. Not the stillness of composure, the stillness of someone who has just absorbed something that has reorganized everything. His face had the specific quality of a man who had convinced himself, over 9 months of legal proceedings, that the outcome was going to be different, that the letter would be dismissed, that the documentation would prove insufficient, that some technicality would provide the cover that his own conduct had failed to provide. He had been wrong, and he knew it. Sandra's expression in the gallery, when I allowed myself to briefly register it, was harder to read, tighter, more controlled, the face of a woman who was already moving toward the next calculation. I turned away from both of them. Patricia and I walked out of the courthouse into a February morning that was cold and clear, the kind of Atlanta winter day where the light is sharp and the air has a cleanliness that feels newly arrived. "How are you?" she said. I stood on the courthouse steps and tried to locate what I was feeling. Not triumph. I had expected triumph, and I could not find it. What I found was more complicated and less satisfying, and I think more true, a mixture of exhaustion and grief and something that might eventually become peace but had not yet arrived at that destination. The specific, incomplete feeling of having done a right thing in response to a wrong thing, and understanding that the right thing, however necessary, cannot undo the wrong one. My parents' estate had been protected. Their intentions had been honored. The house on Ellenwood Drive was going back into proper distribution to be divided as they had intended. My brother and I would not recover from this in any version of the future I could see. Some things, once they have happened, permanently alter the landscape. Kevin made a choice, supported and perhaps initiated by his wife, that told me something about him that I could not unknow. Not the greed alone. Greed, in its various forms, is a human failing I could understand if not forgive. But the specific choice to use the period of our mutual grief, the weeks and months immediately after we buried both our parents, to execute a plan that erased my name from what they had worked 30 years to build. That was a choice, made deliberately in full knowledge of what it cost me. I could not unknow it. "I'm okay," I told Patricia. "I will be." She nodded with the specific, quiet understanding of someone who has sat beside people in many moments, like this one. We shook hands on the courthouse steps, and I thanked her in a way that felt inadequate for what she had done. Then I drove home alone to Atlanta. I called my Aunt Beverly, my mother's sister, the person in the family who had known my mother longest and best, and I told her the ruling. She cried. Not with relief, though that was in there, with something older and more complicated. "Your mother would have been glad, and very sad." "I know," I said. "So am I." I am telling you this story from my apartment in Atlanta on a Sunday morning in late spring. Outside my window, the dogwoods are doing what they do in Georgia in April, blooming with a completeness that always feels slightly extravagant, as though the trees have been saving all winter for this one extended declaration. My mother loved dogwoods. She had 2 of them in the backyard on Ellenwood Drive, and every spring she would call me to describe them as though they were a surprise, as though she had not watched them bloom every year for 30 seasons. The house on Ellenwood Drive was distributed as part of the estate settlement, which was finalized 4 months after Judge Caldwell's ruling. Kevin received his legal share. I received mine. Neither of us received more than our parents intended. I want to tell you what I chose to do with my share of the house, because I think it matters to the end of this story. I did not keep it. I sold my portion, through the estate's process, cleanly and properly, and I used a part of the proceeds to fund a scholarship in my parents' names at the Decatur High School where my mother had counseled students for 25 years. The scholarship is for students who demonstrate financial need and academic commitment, my father's criteria, which I knew by heart. The rest I kept. I will not pretend I did not need it or that being practical about money is a betrayal of the sentiment. My parents were practical people, and they would have understood. But the scholarship is what I tell people about when they ask what happened to the house. It felt like the right way to make sure something of them remained in the place where they had spent their lives. I want to tell you what I have learned from all of this. Not as rules, this story is too specific and too painful for me to pretend it produces clean, universal lessons, but as the honest reflection of someone who has been through something difficult and has been changed by it in ways that are still revealing themselves. The first thing, grief is not the time to make or defer important decisions, but it is often when both of those things happen. I was in no condition in the days and weeks after my mother's funeral to conduct a strategic assessment of what Kevin was doing. That is simply true. Grief has a cognitive and emotional cost that is real and significant, and the people who exploit that window know exactly what they are doing. What I wish I had known, that it was possible to grieve and simultaneously, gently, begin documenting, not with suspicion. I was not ready for full suspicion, but with the simple discipline of writing down conversations and dates and what was said. That notebook, started almost too late, became more important than I expected. If you are in a family situation involving an estate, document everything from the beginning, not because your family will certainly do what Kevin did, but because documentation is neutral. It serves honest processes just as well as disputed ones, and costs you nothing except the habit of writing things down. The second thing, being the one who showed up does not automatically protect you. This is the part of the story that I think many people will recognize: the sibling who drives the 4 hours for the chemotherapy appointment, the one who manages the medication schedule and knows the doctor's name and handles the emotional labor that is invisible precisely because it is done so consistently. That labor is real. It matters. It is not wasted. It mattered to my parents, and it matters to me that I gave it. But it is not a legal protection. The estate does not recognize emotional labor as a claim. The courts do not weigh who held whose hand through the hard nights. What they weigh is documentation and wills and what the law permits and prohibits. Be present. Care for the people you love. Do it because it is right, not because you believe it will be compensated. And simultaneously, make sure that the legal framework reflects what your parents intend, because a will, updated and clear and specific, is the only language the estate process speaks. The third thing, taking someone to court is not a betrayal of family. Defrauding an estate is.
I want to say this clearly because I spent weeks before filing wrestling with the specific guilt of using a legal process against my own brother. The framing that pursuing justice was the act of disloyalty was the framing Kevin had offered and that I had partially absorbed. It was wrong. My mother spent her final months arranging witnesses for a letter she hid in a safety deposit box because she understood that something was being built against me and she was trying to protect me from it. She did not consider her own protection of me a betrayal of Kevin. She considered it the last act of love available to her. Standing up for what is legally and ethically yours, what your parents specifically intended you to have, is not a betrayal of family. It is an honoring of the people who built what is being fought over. Kevin's choice was the betrayal. My lawsuit was the response to it. The fourth and final thing, justice, when it arrives, does not undo the loss. It restores the record. The ruling did not give me back my parents. It did not give me back the brother who had stood beside me at 2 funerals. It did not restore the relationship to what it had been before the kitchen on Ellenwood Drive, before Sandra's evaluating expression, before 11 weeks of planning executed in the window of my grief. What it did was restore the record. It established officially and permanently what my parents had actually intended. It protected their work, 30 years of a house, 30 years of savings, from being redirected in ways they had never sanctioned. It gave my mother's letter the legal weight she had wanted it to have. That matters. It is not everything, but it matters. My name is Nadia. I am 31 years old and I live in Atlanta, Georgia. My brother tried to take what our parents left me. I took it to court, and the court, slowly and imperfectly and at significant cost to everyone involved, did what courts are sometimes able to do. It told the truth. I did not get my brother back.
I did not get a family that looked the way it had when both my parents were alive. I did not get the clean, satisfying resolution that grief deserves and rarely receives. What I got was a scholarship in my parents' names at the school where my mother spent 25 years caring for other people's children, and the knowledge that I stood up for what they built. That is enough. It is not nothing. On most days, it is enough. If this story reached something in you, share it with someone who needs to hear it. Subscribe for new stories every week. And if you have ever been the one who showed up, who was there, who did the invisible work, leave a comment. You are not alone, and what you gave was real, even when no one recorded it.